the lunch break, and as well as welcoming you from the sessions that we just had, the first preliminary sessions. Next up, we are going to invite Frank, a monitoring and evaluation officer and a statistician, who is going to announce to us officially the results from the first rounds, the first 2 rounds. Then Frank is going to announce to us the results. From those results, we shall determine the top 4 teams to proceed for the semi-final round. Is that clear? The best teams, the top 4 teams, are going to proceed to the next round, and we are going to go through a lots play whereby you choose your opponents. That session is to find out who does come. Going to appear before a couple of judges. One panel is going to sit in this room. Going to sit in Sezibwa Hall, is around the corner. The corridor on my left, just next there. So without wasting any more time, I call upon Frank Ategeka to come here and announce to us our results and also announce the best teams. Just so you know, the marks that are about to be announced is the average you just went through. The averages for your play are concluded, and we have winners who are going to award in the later part of this day. So the winners proceeding to the semi-finals are determined based on just the oral submissions that you just made in the first 2 rounds today. So thank you. Frank, you're welcome.
Thank you so much, Seth, and the participants for today's MOOT. So I want to, like Seth mentioned, teams that are going to the next level are obtained by using the average from the first round and the second round. Is that clear? And then, in case you want details of your scores, for example, you might be interested in knowing how you performed as an individual. Please, you can be able to check on us later. I have all the details here. And then in case you want to see the overall picture of your university score, you can as well see us later. And then in case you also want to see individual performance for round 1 or round 2 or any of those, including the final scores, you can as well check on us. So these are the scores. I first read the top 4, and then I also read you the details of the scores for all the participants. So in the first position of the top 4, we have Team K. We have Team K with an average score of 83.3. And then in the second position of the top 4, we have Team F with an average of 80.3. And then in the third position of the top 4, we have Team L with an average of 79.3. So the difference between the second and the third was actually 0.1. So that's how tight it is, right? And then in the fourth position of the top 4, we have Team E with 73.5. So those teams are expected to be going for the semi-finals later after here. And the details of who is going to be meeting who, I think Esther or Seth will be able to communicate to that. Then the rest of the teams, this is how we are able to fare. Team A tied with Team B with an average of 69.3 each. And then Team C scored 70.0. These are not reading them on order, right? Team C, I said 70.0. Then Team D scored 61.5. And then we had Team G scoring 63.0. And then we also had Team J scoring 62.5. But later on as well, we also had Team M and N. M for man and N for name, 59.5 each. There was a tie as well on these two teams. So those are the scores, and I wish the best, the winning team, the best of luck. Thank you so much.
So much, Frank. Another round of applause for Frank, please. Very, very tight margins. So at this moment, I'm going to call upon Esther. Yes, Esther, please. Esther is going to take us through the next round. The next round is about choosing who is facing who before which panel. So I wish you the best of luck as you pick your opponents. And please, for the teams that are not making it to the semi-final rounds, you have really done well from the marks you've had. Please clap for yourselves. Yeah, very, very tight margins, but you are all winners in your own right, and you really deserve that. You made yourselves proud. So, can we have the coordinators of the following teams step up to the front? Which ones are they? Can we have the coordinator from Team K? Team K, do you have a coordinator? Is Team K here? Where are my clerks? My dear clerks, kindly ensure that we have all the teams in the room. In the next 30 seconds, please. Okay, in the meantime, can we have the coordinator from Team F? Yeah, to come. Just wait for you. Team F. Can we have the, yes, just, yeah. Can we have the coordinator from Team L? Can you also have that coordinator from Team E, CLME? Is the coordinator from Team CLMK here? Can you come to the front? Yeah, put them on the table.
As to pick their lucky draws, I just want to encourage those who haven't made it that there is a chance and we are all winners, like Seth said. But also to mention that to all the teams that would love to know their individual marks, including the marks that you scored in your pleadings and submissions, which were marked by our judges here, you feel free to reach out to us. We shall send you your team's pleadings, just your team, so that you can know how you fared. And yeah. There's going to be a panel of two. Why these people are standing here is because we want to do a lucky draw. So 2 of them have to be appellants, them have to be respondents. But for us to get who is appearing before panel 1 as an appellant and as a respondent, we can't. Team member is going to pick one, and once you pick one, you're going to read out to the team or to the entire room what you have chosen. It has panel 1, appellant, panel 1, respondent, and better. So once you pick a lucky draw, you're going to announce to us. There's a microphone behind you. Announce to the entire team, and once that's done, we're going to tell you which panel you're going before and which room you're going to meet. So you can all pick one. Just pick any. Behind you. You don't have time, so you can announce. CLM what? First start by telling us your... Yes?
Panel 1, respondent.
CLM? What team is that?
E.
Yes?
Panel 2, appellant. CLMK.
Panel 2, respondent. F.
So CLML and CLMK, no, CLML and CLME, you're appearing before panel 1, which is sitting here in Katonga Hall. That panel has 3 justices. That's His Worship Lumune Timothy, His Worship Wegoe Joel, and His Worship Ariokot Esther Joyce. So you're staying here. CLMK and CLMF, you're appearing before panel 2, which is in Sezibwa Hall, just across. That panel has 3 justices. That's His Worship Opich Christopher, Her Worship Kambeda Lydia, and Her Worship Nangobi Maria Jackie. May the best team win.
Okay, for panel 1, our clerk is Chitandwe Rodney. Kindly take charge of your courtroom. And for panel 2, our clerk is Kasibante David. Kindly take charge of your courtroom. And to the rest of us, please feel free to join any of the courtrooms and support your colleagues. Do not leave. Do not leave. You can stay around. You know we've reserved some accommodation for you. Please stay around and cheer on your colleagues. You're all winners. Do not disqualify yourself in your hearts. Can we do this very fast, please? The team appearing before panel A, panel 1, I expect that you're already making your way to the front here. The same applies to the team before panel 2. After that round, we are all going to go in this main hall and we go through the award ceremony for the first round of awards. That is the team with the best submissions, the team that prepared the best pleadings. So thank you. See you later after these semifinals.
and I'm Timothy Munye, Justice of the Court of Appeal and the head of the panel. You have 25 minutes to make your submissions. We shall not guide you on how you utilize the 25 minutes, but the clerk will keep reminding you so that you work within the time frame that has been given to you. I'm also confident that now you're more familiar with the case, and we certainly going to hear better submissions than what we had at the trial court. I wish you good luck as you submit to this honorable court. Clerk, you may wish to call the file, and we shall have the appellants. Where are the appellants? Can you submit a list of your names and then the respondents? Maybe what I forgot to mention is that when you're done with your submissions, the court will stand over. Then we shall go to chambers and deliberate on the results, and then later come back and announce the winner for this appellate stage. Thank you.
Team E versus Team L. Proceed.
That's E and L. L. You're the appellant. It's L versus E.
Your Lordships, I am Ejiku Justin, the Attorney General, the first appellant, pairing together with Counsel Ankunda Shiba for the second appellant. The respondents are being represented by Counsel Laoko Miriam and Counsel Mogisa Derek. Your Lordship, this appeal is lying before the Court of Appeal by virtue of Article 134 of the Constitution, which mandates this court to hear appeals that arise from the decisions of the High Court, together with Rule 30 of the Judicature Court of Appeal. We are appearing before you in this appeal on four grounds of appeal which arose out of the decision of the High Court. And the grounds of the appeal, the four grounds of appeal are that the land trial judge erred in law and fact when he held that the state did not execute its duties in the protection of human rights, and therefore leading to the violation of the right to life, health, and equality. The second ground of appeal is that the land trial judge erred in law and fact when he held that the state did not ensure that health facilities were well stocked and that health personnel were untrained. The third ground of appeal is that the land trial judge Adin Law, in fact, when he held that the government did not implement the sexuality education policy, and lastly, that the land trial judge Adin Law, in fact, when he held that Kwero High School did not ensure that students were protected from exploitation by teachers. Your Lordships, I'll be handling ground 1 and ground 2, and then my co-counsel will handle ground 3 and 4. While disposing of ground 1 and 2, Your Lordships, the appellants are going to argue based on the following arguments. That the state of Oyanda did all that was within its reach to put in place measures that would ensure the protection of the right to life, right to education, and right to health. Whereas we adequately agree that the right to health is provided for under Article 45 of the Constitution of Oyanda, which is also expressly stated in Article 12 of the International Covenant on on Economic, Social, and Cultural Rights. It is the appellant's right that the appellant's submission that these rights were rights that are achieved progressively over time. Lordships, the appellant submit that pursuant to paragraph 30 of General Comment number 14 of Article 12 of the International Covenant on Economic, Social, and Cultural Rights, which we would like to read hand in hand with the case of Sehad and 3 others versus the Attorney General, in which it was stated the progressive realization of rights was upheld, that states have got an immediate obligation to ensure that, one, in the exercise of the right to health and others, there is an equal treatment and equal provision of health services. It is the applicant's submission, therefore, that pursuant to paragraph 14 of the facts, the government put in place a hospital that was just 40 kilometers away from Kwero High School, and also put in place a health center by the name of Busi Health Center. It's therefore our submission that these were fundamental steps toward the realization of the right to health, which the appellant submit that is a right that can be achieved progressively given the financial constraints faced by the state of Oyanda. It's therefore the appellant submission that the land trial judge Adin Law, in fact, when he stated that the state failed to put in place, measures to protect the human rights. Therefore, our submission that by putting in place a hospital and a health center, the state was committed and ensuring that the right to health was being promoted or protected. Furthermore, the appellant submit that by putting in place a school called Kwero High School, amongst other institutions which are not expressly mentioned, the state of Oyanda had commitment towards ensuring that the right to education, which is provided for under Article 30 of the Constitution of Oyanda, was upheld. Your Lordship, it is the appellant's submission that the incidence of Ariana was just a mere single incident that happened in a particular school by the name of Kwero High School. It did not happen in any other place. The government has put in place health facilities that are ensuring the monitoring and the promotion of the right to health and right to education of the citizens of the Republic of Oyanda, and therefore a single incident at Kwero High School should not be an issue that will make this honorable court to impute liability and failure to fulfill obligation on the part of the state.
Counsel, I have a question.
Yes, please.
Is it your argument that the state of Oyanda fulfills its rights by just establishing a hospital and a school? Is that sufficient?
Your Lordship, it is our argument that the right to health, amongst other rights, are progressively achieved, given the financial constraints of the state of Oyanda, as given out in Article 12 of the International Covenant of Economic, Social, and Cultural Rights, which recognizes the progressive realization. Your Lordship, putting in place a hospital and a health facility and even a school was a deliberate and a direct step towards achieving Article 12 of the International Covenant on Economic, Social, and Cultural Rights, which talks about the right to health. And therefore, this was a particular move towards achieving the right to health. Your Lordship, we would like to further submit that the right to education and the right to discrimination, as alleged by, as was given in the High Court, was being promoted, and the state put in place measures to ensure that these various rights were protected by establishing a school, which school, according to paragraph 8 of the fact, was a school which accommodated both girls and boys, and that in this school there was a nurse. This was a protection towards ensuring the status and the safety of the students while at the school. It is further the appellant's submission that having a school which catered for both sexes was a move towards ensuring equality in having the right to discrimination combated.
Counsel, another question. Is it your argument that the incident at the school was a single identified incident?
Yes, my lord, it was a single incident that cannot be used to judge the state on the entire
Is
scenario.
there a difference between losing 1 life and 10 lives?
Your Lordship, there is a difference between losing 1 and 10 lives in a way that when a state is constrained but manages to keep very many people, it shows its commitment towards the progressive realization of the particular right. In this sense, many rights have been saved. This was just a mere small failure for which we hold that the state shouldn't be held accountable for. It should be held that the state has put in place measures to ensure the progressive realization of the various rights. Your Lordships, permit me to invite my learning friend, Counsel Ankunda, to proceed with the remaining grounds.
Counsel, before you sit, personally have one question, and I'll also ask Her Lordship to ask you a few questions, if any. You are in the Court of Appeal, right?
Yes, Your Lord.
What is the duty of the First Appellate Court in hearing appeals?
Your Lordship, the duty of the First Appellate Court was well elaborated in the case of Beatrice Odongo and Noah Ochola versus Tom Engineering Consultant Limited, in which it was clearly stated that being the first appeal, particularly this one, the court is enjoined to reappraise the evidence and draw its own inference of the fact therefrom. This same holding was also held in the case of Chifamunte versus Uganda. It's therefore the duty of this honorable court to hear, basing on the facts that we are given and evidence adduced in the High Court, to have a fresh reappraisal of these facts again.
Thank you, Counsel. I think I'll ask Ankunda.
Okay, thank you, Counsel. Let's hear from Counsel Shiba.
Your Lordships, allow me to proceed with the second raised issues.
You state the ground again so that the court can follow your discussions, and then you proceed. Thank you.
Right. Your Lordships, allow me to proceed with the third and the fourth grounds that have been raised. On the third ground, Your Lordships, we maintain that the land trial judge erred in law and fact when he stated that the government had a duty to pass.
Yes. Okay, can you first state the grounds again, the 4 grounds, and then you proceed with the 2 grounds that you are urging so that they can be in position to respond?
Much obliged, my lord. The first ground of appeal is that the land trial judge erred in law and fact when he held that the state did not execute its duty in protecting human rights. The second is that the land trial judge erred in law and fact when he held that the state failed to ensure that health facilities were well stocked and health personnel trained. The third issue is that the land trial judge erred in law and fact when he held that the state, the government, had a duty to pass a school health and sexuality policy. And the last issue is that the land trial judge erred in law and fact when he held that Quero High School failed to provide failed to ensure that students were protected from exploitation by teachers.
We shall give her 10 minutes, because of that interjection. Please proceed, Counsel. State the grounds again, and then you proceed with the submissions.
Your Lordships, allow me to proceed with the last two issues. The first being that the land trial judge erred in law and fact when he held that the state failed to ensure that the land trial judge erred in law and fact when he held that the state failed to ensure that health facilities were well stocked and health personnel were trained. Firstly, I would like to maintain that these rights can actually, the retrogression from different rights can actually be justified under the general comment number 14 of Article 12 of the International Covenant on civil, cultural, and economic rights. And this clearly stated that if a state can prove that it has exhausted all the possible remedies to ensure that these rights are catered for, then that retrogression can be accepted. I'd like the court to look at the case of Sobramomei versus the Minister of Health, KwaZulu-Natal. It's a case of 1998. In this case, it was held that the provision of health logistics was premised on whether there would be substantial inroads in the health budget. Your Lordship, my Lordships, Your Lordships, I would like to maintain that for as long as a state has put in place all the possible remedies to ensure that people's rights are respected, then it should be given credit for doing this and at least should be excused for some of the things that seem not to be right and in place. Also, I maintain that I would like to go to the second, to the fourth ground that was raised, that the trial judge erred in law and fact when he held that Quero High School failed to ensure that the students were protected from exploitation by teachers. Quero High School must have done all that was within its means to ensure that students was protected. In the first sense, there was a school nurse who was to ensure that there was a sexuality policy and education taught to the schools. The fact that a nurse was employed in the school is enough to show the commitment of the school towards educating the students on their sexuality and other grounds. Surely everyone knows it clearly that when a person is going through their nursing course, they're also taken through sexuality education and they are expected to provide it to their patients and any other people that they attend to. So Quero High School did its best by employing a nurse. And then again, Quero High School ensured the separation of students during the prep times. For the fact that the boys were put in a separate room, the girls were also put in a separate room, that is a clear
sign of their efforts to ensure that the girls are protected from being either molested or abused by the boys. Now, a teacher who comes out during prep times and instead of punishing the student goes ahead to have sexual intercourse with a student, that is clearly a frolic of his own. It cannot be held against the school. It cannot be held against the school.
Council, I have a question for you. When Quero High School came to know that a teacher had misbehaved, did they rein in on the teacher? What measures did they put in to bring the teacher to book to answer for the allegations?
I'd like to hold that Article 120 of the Constitution is clear that the Director of Public Prosecutions is supposed to instruct the police to carry out investigations on any matters arising in a government-aided institution or any institution that is run by the government. Quero High School is a government-aided school. If these people needed further investigations, then it was the Director of Public Prosecutions who was supposed to conduct any such investigations and not Quero High School itself.
Did the head teacher do that? Because when the information was brought to the teacher, to the head teacher, what step did he take in that line?
I would like to maintain that it is not the head teacher that is supposed to conduct any such investigations. In any case, the student, along with other students who claimed to have been sexually assaulted by the teachers, was supposed to maintain their stand and report to the head teacher, and report to the police, who were to handle this matter further, along with the Director of Public Prosecution.
Allow me to proceed, Your Lordship. Proceeding, I would like to state that Quero High School can still be accountable for the actions of a one Mr. Robert Kelly, who was on duty. The case to this is Charles Twagira versus Attorney General, where it was noted that where a person acts beyond his official capacity and beyond his scope of employment, personally, therefore, Quero High School is what are not responsible for the actions committed by one Mr. Robert Kelly. We implemented policies, followed the law as Quero High School, made sure there was a nurse, made sure the students were separated during prep time, and therefore, the irresponsibilities of a teacher cannot be held on the school. Thank you so much. I beg to submit.
Council Akunda Shiba. You stand up when you're addressing court. Excellent. You are in the Court of Appeal. What are the powers of the Court of Appeal in hearing appeals?
The Court of Appeal has powers to reverse the decision that has been made by a lower court.
Is that all?
The Court of Appeal also has powers to hear matters depending on the evidence that has been presented before it, as well as to grant costs that are due.
Okay. Justice, any question? Okay, thank you. Co-counsel for the appellants. We shall now proceed to hear from the respondents, or you could simply concede and then we close and go. Hey, you don't want to concede. You want to fight. Okay.
May it please this honorable court? 12. Between the two of us. For me. Each person, yeah. Much obliged, thank you. May it please this honorable court? My name is Miriam Luoko, appearing on behalf of the respondents, and with me is my co-counsel, Eko Magisha. I will use 12 minutes of this honorable court's time to respond to the ground 1 stated by counsel for the applicant and ground 2. And my co-counsel will respond to grounds 3 and 4. My lord,
Counsel, I will request you to state the grounds
Much
for which you're responding to, so
Much-
that we can be able to follow your submissions.
Much obliged, my lord. Counsel for the applicant submitted that the learned trial judge erred in fact and in law when he held that the government failed to protect the rights, human rights. And secondly, that's ground 1. And ground 3 states that the counsel for the applicant stated, for the appellant, that the duty of the trial judge erred in fact and law when it said that the duty to implement the school health and sexual education policy was on the government of Ayanda. My lords, the case before this honorable court is about the girl child. This court is dispensed with a task to uphold the right of pregnant girls of school. In the present case, Ariana Kamisha was a girl who was raped in school and sent home because she was pregnant, and her right to education was violated. Now the respondent submits that the High Court rightly held that the government of Ayanda violated the rights to education, health in the present case. The respondent submits that it's the submission of the respondent that in the country of Ayanda, girls are forced into early marriages. And this violates their right to education because they're forced to leave school. The respondent submits that the government has a duty to protect girls from these harmful practices. And indeed, the High Court held that the respondent submits that the High Court was rightly stated that the girls' rights to education were violated. Now, the Maputo Protocol, under Article 5, prohibits harmful practices on early marriages. In the general comment number 18 on the rights of children, the committee held that child marriages are accompanied by early pregnancies, and this contributes to the high rate of school dropouts. The respondent submits that the government had a duty to protect these girls from these harmful practices of early marriages. They are forced to leave schools, my lords. This court is dispensed with the task to promote and uphold the rights to education for young girls. And it's the submission of the respondent that the High Court did not err in law and in fact by saying that the government violated the right to education. Now, Article 2 of the Convention on Elimination of Forms of Discrimination Against Women places an obligation on states to take appropriate measures to abolish harmful practices that exist in the society. Now, the respondent submits that the government had a duty to ensure that these harmful practices were not being practiced. And secondly, these very practices were violating the right to education. Now, the counsel for the applicant stated that the government did not violate any rights. My lord, the counsel for the respondent submits that furthermore, the laws on abortion in Ayanda, Ayanda entered a reservation under Article 14.2c of the Maputo Protocol, which prohibits abortion in cases where girls have been raped. And the submission of the respondent is that Ariana Kamisha was raped by her school teacher. The reservation on Article 14.2c of the Maputo Protocol prohibits abortions in cases where girls have been raped. The government entered a reservation on that specific provision. The respondent submits that this specific provision violates the right to health. The counsel for the applicant submitted that the government of Ayanda was not violating any rights. The respondent asked this honorable court to uphold the rights of young girls. In this present case, Ariana Kamisha self-induced an abortion. because she was raped. And this very protocol, the Maputo Protocol under Article 14.2c provides for instances where girls have been raped. The state of Oyanda entered the reservation, and the respondent submits that in the present case, Ariana, if the provision was not reserved by the state of Oyanda, she would have access to abortions, which is a right under her sexual and reproductive health rights. My lords, counsel for the applicant further stated that the government of Oyanda did not have a duty to implement the sexual and education health policy. Now, the respondent submits that the sexual and health education policy under Article 14 of the Convention on Elimination of Discrimination provides that that policy was provided with the aim to prevent sexual exploitation amongst adolescents. In the present case, my lords, these young girls were being raped. Irana Kamisha was being raped in school by her teacher, and had she had access to information provided for by the sexual health and education policy, she would have had the right to redress for her issue. Now, the respondent submits that that the applicant wrongfully stated that the government does not have a duty to implement the sexual health education policy. The respondent submits that they do have a duty to implement this policy because it will protect the rights of girls in school and give them the access to information provided for, which is provided for under Article 40 of the Constitution of Oyanda, which provides for the right to access to information. Now, by not implementing that policy, the government of Oyanda was violating the right to education. Now, education should be read together with Article 40, which means access to information. Had these young girls had access to information, which the sexual health and education policy provides for, they would have had the right to redress on what to do on issues where you're being raped in school and you don't have the right remedies for you in that time. Now, the respondent asked this honorable court to find that the government has a duty to implement this policy. And I would like to persuade this court, this honorable court, with the case of AR and RL versus Switzerland, where the court held in 2019 in the European Court of Human Rights, where the court held that this policy was being implemented to prevent sexual exploitation of young girls with the aim of giving them information on how to handle situations such as when they're being molested, raped. And in the present case, Ariana Kamisha was facing those exact issues. If this honorable court will allow me to further persuade it with the case of Sierra Leone, the Republic of Sierra Leone versus WAVE, Women Against Violence and Exploitation. And this case was before the Community Court of Justice 2019, where the court emphasized that the state has a responsibility to ensure that the girls are protected in schools, and also that when they attend schools, that they should be given the right to education just as their male counterparts. My lords, the respondent submits that the government failed in its duty and that the High Court did not err in law and in fact, but rightly stated that the girls of Oyanda and girls in Oyanda's rights were being violated under the right to education, health. I so submit.
Well, thank you, Council Miriam. I see you have a passion for access to justice for women and girls. What are some of those other rights of women in the Oyanda Constitution?
Much obliged, my lord. The Constitution of Oyanda provides for, under Chapter 4, provides that, that under Article 33, the rights of women, that women should have full and equal dignity of the person with men. Secondly, under Article 30, as I already stated, that they have the right to education. and that they have a right to be, the right to freedom from discrimination, and furthermore, that the girls have a right to health. Now, the right to health is not expressly provided for in the Constitution of Oyanda. However, Article 8A, which enforces the national objectives and principles and puts them into force of law, Objective 14 and Objective 20 provides for the rights to health.
Justices, any questions?
Thank you. Council, I would like you to state the harmful practices that were taking place, that were harming the girl child in Oyanda.
Much obliged, my lord. In the case of Oyanda, according to the Memorandum of Appeal, girls in Oyanda were being forced to go home from school because of early marriages. Now, it clears that 40% of the girls in Oyanda were not receiving formal education due to cultural biases, and 33% of girls in Oyanda dropped out of school because of early marriages. Now, this practice is harmful because it violates their right to education and violates their right to health.
Just one question. Where do you derive your statistics from?
Much obliged, my lord. According to these statistics were provided for by the UN Women Report in 2016.
Okay, time up. Thank you. Council Mugisha states the grounds so that the panel can follow the submissions.
Much obliged, my lord. Mugisha Eko, as earlier introduced my co-counsel, and I'll be using 10 minutes. I'll reserve 2 for Sari Battle. Much obliged. My lord, the third ground for appeal, it's in regards to the violation of the failure of the state of Oyanda and Kwelo High School to provide, the failure of Oyanda to provide protective equipment, healthy protective equipment, as well as trained personnel in the state for the citizens of Oyanda. And the fourth ground of appeal, it's in regards to the failure of the state, rather failure of Kwelo High School to provide a protective environment free from sexual exploitation of the students of Kwelo High School. Much obliged, my lord, if we may proceed. My lord, the appellant has submitted that the trial court erred in fact and in law, holding that they have an obligation to fulfill and to meet the obligation in regards to human rights. And it's our submission that indeed these obligations do exist. And we are going to prove to this honorable court that the appellant indeed has an obligation, and that obligation was breached, and the breach resulted into violation of the rights of the citizens of the state of Rwanda. My lord, in regards to the right to health, the right to health is not subject to progressive realization, as it has been submitted by appellant. However, we do recognize that the right to health indeed is subject to progressive realization. However, and it is our submission that even though it is subject to progressive realization, the state ought to take measures to make sure that it fulfills to the highest standard of this particular right. And it was stated in the case of Sehad versus the executive of Mulago and AG, it was stated by the Honorable Justice Lydia Mugambe that states cannot run away from the obligation to provide adequate maternity health care as they are under a continuous and expeditious, and to provide expeditious and effective, expeditiously to provide these services, as well as to ensure that their medical personnel are well trained. This was further reiterated by the Honorable Justice Bisharaki in the case of Sehad versus the Attorney General, Constitutional Appeal 16, of 2011. Our submission that indeed the trial court held that the failure of the government to equipment to the medical facilities as well as well-trained professions in these particular clinics and hospitals and facilities were violated their right to health. The right to health, of course, is provided for by our constitution as it has been submitted by my co-counsel. Again, Article 12 of the International Covenant on Economic, Social and Cultural Rights recognizes that everyone has a right to enjoy the highest attainable standard of physical and mental health. And it has submission that indeed the royal court was correct to hold that the failure of the government to provide this particular equipment as well as well-trained personnel was a violation of the right to health of the citizens of Uganda. Furthermore, Your Excellence, in General Article 14 of the Committee on Economic and Social and Cultural Rights does provide that these rights ought to be met, and the state has to prove that their failure to provide these services they were unable to provide for them, and they sought international help in that regard, as well as they did all they can they carried all appropriate measures to ensure that they fulfilled these obligations. And that's our mission, that indeed they failed to fulfill these obligations, and the trial court was correct to hold that they violated the right to health. Moving to the fourth ground of appeal, it is a submission of the respondent that indeed the High Court or the trial court was correct to hold that the failure of Kwelo High School to protect the children from sexual exploitation was in violation of their right to education. The right to education is provided for under Article 30 of the Constitution of Uganda, that provides that everyone has a right to education. And the failure by the state to provide and protect the children against sex exploitation was indeed a violation of that particular right. Article 27 of the African Charter on the Rights and Welfare of Children mandates every state to, generally requires every state to protect the child from all forms of sexual exploitation. And it's our submission that the failure of the state to protect these children from exploitation was a violation of their right to education. In its general comment,
Answer.
Yes, my lord.
I would like you to address court on the obligation of the parents. Where do we draw the line where the parents stop and where the state comes in protecting children from sexual exploitation?
Much obliged, my lord. Whereas we do recognize that most of these international provisions as well as the Constitution puts an obligation on the state, but we will have to rely on Article 20, Clause 2 of the Constitution of Uganda. It does provide that the rights and the freedoms of every individual shall be protected and respected and upheld by the agencies and organs of the state and all other persons. So we do submit that indeed every person has an obligation to protect and respect and uphold the human rights of the citizens of Uganda. The parents, in regards to the obligation of the parents, we'll have to rely on Article 34 on the rights of children. Clause 1, it provides that subject to laws enacted in the best interest of children, children shall have the right to know and be cared for by the parents or those entitled by the law to bring them up. So it is our submission that indeed parents as well have an obligation in regards to their children. However, we will have as well to rely on the committees, on the Committee on the Rights of the Child, its general comment, number 1, which stated that the right to education includes the content of the curriculum, but also the education process, as well as the environment within which the children, the education takes place. And it further provides that whether it be at home or school, and where children do not lose their human rights by the virtue of them going to school. And we find that by the mere fact that these children were in the hands of Quero High School, they had an obligation. They had an obligation to respect, they had an obligation to uphold, and they had an obligation to respect, promote, and protect these rights. And it's our submission that their failure indeed, as it was held by the trial court, they violated their rights to education. In regards to the last ground of appeal, much obliged, my lord, those were the grounds of appeal. Counsel for the appellant praised that indeed this honorable court upholds the judgment of the trial court. Much obliged. Yes, counsel
Your
for the
counsel.
respondent, beg your
I
pardon.
know. Mr. Eko Mugisha.
My lord.
What are the powers of the appellate court?
Much obliged, my lord. According to Article 134, Sub-Article 2 of the Constitution, it does provide the powers of this particular court. If I may read it verbatim, my lord. It provides that, that's Article 2, it provides that an appeal shall lie to the Court of Appeal from such decisions of the High Court as may be prescribed by the law, my lord.
Powers.
Could you restate your question for clarity?
What are the powers of the Court of Appeal when hearing first appeal?
Give me a minute. Much obliged, my lord. We would love to rely on our Judicature Act. It provides under Section 32 the general powers of the court, and provides that on any appeal, the court may, so far as its jurisdiction permits, confirm, reverse, or vary the decisions of the High Court, or remit the proceedings to the High Court with such directions as may be appropriate, or order a new trial, and make any necessary incidental and consequential orders, including orders as to cost. That's why we pray to this honorable court that they indeed uphold the judgment of the trial court.
Judge, any question? Any rejoinder? Thank you, counsel.
Much obliged.
In 2 minutes, if any.
Your Lordships, the appellants would like to make a few rejoinder on a few submissions that were made by the respondent. The respondent submitted that girls in Oyanda were being forced to leave school. And this was a violation of Article 30, which is on the right to education. It is the appellant's submission that the state of Oyanda has done all within its reach to ensure that actually the right to education is enforced and respected. Pursuant to paragraph 11 of the facts, it is very clear that Ariana, the young lady who lost her life, was on a bursary at a school. This shows the commitment of the school to uphold and respect children's right to education. And therefore, it is the appellant's submission that the school is committed towards the realization of the right to education, just as it is committed at ensuring that the realization of the cultural practices are actually stopped. The respondent submitted that there were a lot of cultural practices in Oyanda that were affecting the right to health. It is the appellant's submission that the appellant has ratified international statutes, such as the Maputo Protocol, that prohibit the application of these bad cultural practices, and pursuant to Article 287 of the Constitution of Oyanda, the state is mandated to honor those statutes. Therefore, the appellant's submission that the appellant has put in place measures and steps towards having the right to health achieved in the state. It is therefore the appellant's submission that given the financial constraints of the state of Oyanda, Oyanda has engaged on the progressive realization of these various rights as had been earlier on explained. However, some of the rights are actually subject to limitations under Article 43 because where it is demonstrably justifiable in a free and democratic society, there can be limitations of the right of education and...
Okay. Thank you so much, Council.
Much obliged.
We are going to stand over this session to enable the justices to go and deliberate on the submissions and then return and give a ruling in form of results. Okay. Court clerk? No. Can you do that again? On your table. Court is in session. Welcome back. So we are done with the deliberations. I'll just highlight a few things about the importance of mooting, since this is to be my final address to you. From here, you'll go back to the university. Then my colleagues, the justices, will also say a word or two, and then I'll wrap it up. So I want to thank you again for participating in this activity. It is no mean task, I understand. It's very engaging, it's time-consuming, but it is good, you know. You leave a mark in your faculty, you leave a mark in your respective universities. And of course, it comes with so many advantages. Networking. Make sure you get a new friend, okay? Make sure you get a new friend. Do not go back the same way you came. Don't go with old friends again. Meet new friends. I believe it has also helped you to improve your research and writing skills, because it didn't start today. We started with pleadings, submissions. That's an art, and you know that's a lifetime skill, okay? Building confidence, you know, all of you are brilliant chaps. You're really so good, and that's what the law profession is about. When they give you a mic to speak, you speak as a lawyer. That's why you are hired. You are hired to speak, okay? Practical knowledge, I'm quite sure by now you know something about human rights, rights of women, rights of children, which is a good thing. So for me, I really just want to congratulate you. Do not really mind so much about the results, but the fact that you came, you stood, you were confident is good enough. So I'll give my colleagues to just say one or two things, then I'll wrap it up. And also a surprise gift for one of you.
In addition to what my land brothers stated, and whose submissions I associate with, we shall not be here tomorrow, and most likely you'll be facing another team and another battle. You understand? Or it may not even be tomorrow, it may be another year or another season where you'll face. But I want to say, from morning session to now, there have been an improvement. You know, because every time you go for round one, okay, you say okay, round two, you say okay. But now you're seeing that the people you're sending to the finals are all good. Sometimes you want to send everyone to the finals, but that is not the purpose of competition. There has to be one going and one staying, but doesn't mean that the one staying is not good enough. It may not have just been their day. But a few things I had noted. One is you have to know the court before which you're going to appear. You struggled a lot. You had your arguments, yes, but you struggled a lot with the powers of the court. That is the basic thing. The first thing you raise, what? Have to know off your fingertips, even without looking at the laws. You have to say, where am I going? What are their powers? What can they give me? Because you cannot go to a court when you don't know what you're going to get. Then also how to address the court. It is very, very important that at any one time when you ask a question, you know how to address the court. It is not only in your opening remarks where you address the court. If His Lordship asks a question, you have to refer to them as their title, with their title. Don't go straight away and answer the question and forget to refer to them with their right title. Then also the purpose of the MOOT. We are privileged to be here, even us as judicial officers. It is not every day that you'll get a MOOT on reproductive health. So when we come here, it also refreshes our minds. So when I asked a question on one life or the whole world. You have to know that the purpose of reproductive health and life at large is every life counts. Whether it is 1 or it is 10, they all count. You don't have to kill the whole world. You don't have to kill the whole world for life to matter. Even the life of a single person matters. That is what is called fighting for life and reproductive health at large. Then you have to learn how to speak to the court. You have to differentiate between a commercial conversation, a conversation concerning life. Like I was telling my earlier participants, when you're speaking about things concerning life, you have to know even the panel you're presenting your arguments to may be affected by the same things you're arguing about. But the way you package them matters. So you have to speak to the heart. Because the law is not about what's in the books. It's also in the heart. You understand? So you learn how to speak to the heart. And normally this comes in your opening remarks. By the time I hear your opening remarks, I may not have to grade your other arguments. Because at the end of the day, it's about the art of persuasion. So those are the few remarks I had. I want to wish you, whichever team that will go through, I want to wish you all the best. And the team that has not made it, I want you to know that the fact that you're two there and all the other people are still at your university should mean something to you. You understand? Because you've left the whole world out there and you're here representing them. So everywhere you go, you should know that people trusted you and they can trust you again. I wish you all of you the best.
Thank you, Judge.
Thank you. I'd like to appreciate every team here. Well done. It doesn't matter what you're seeing, but you have done well. I was able to see a good blend of the law and the facts as the teams kept progressing. Of course, at the beginning, they were a bit detached, but towards the end now, we are seeing you now in charge of your case. Because at the beginning, you had not yet owned the case, so the arguments were not coming out well. But as you kept on coming through the rounds, it became clear. So that makes it better for you when you get another opportunity to go to another MOOT, or even if it's at university and you have a competition, you just know that when you're given the facts and you are the one representing the particular person, it now stops being facts. It's now your case. It becomes your case. So it's no longer just detached facts on paper. You now own the case and you argue for the person, you argue for whoever you're representing. But you all did well. I like the way you brought out your submissions. I like the way you worked hard, sleepless nights to reach this point. So you are all good. The fact that you're here, you have done well. For the semi-round team, your arguments needed to be straightforward. Because the Court of Appeal doesn't have a lot of time. They'll just, when you appear before them, they want you to go straight to what your issue is. So you have to come when you know what are the grounds, what are my grounds, and what is the law supporting me. You can actually do it in three phases. You speak about what your case is, what law you're relying on, and buttress it further, maybe with a decided case, and you move on to the next ground. So you did well. Congratulations.
Okay, before I release the results, every time I get an opportunity to talk to meet young people, I want to leave them with a few tips. I was a lecturer for 7 years. I think I lectured some of you. No, I stopped lecturing. I got tired. I got tired. But how you make it, discipline, okay? Discipline, hard work, okay? Commitment, don't give up. These two colleagues that I'm seated, these are my classmates, but good habits follow you. I can say something about Joel because I studied with him. I can say something about Esther, you know. These are the same guys, you know, like guys who stand out. You always meet Miriam, you're going to meet Echo. You're going to, you know, because there is something about you. Be focused, get to know where you want to be. The legal profession is small, get to know each other. After 5 years, we shall become colleagues, or even 3, we shall become colleagues. You'll be the other side. If you want to join the judiciary, it's also open. You can join. So what am I saying? Hard work, discipline, okay? Hard work and discipline. So how we came up with the results, we assessed each team individually. So Justice Joel, Timothy, Justice Esther, we assessed each one of you individually. After that, we did the average still individually for each team. Then we now got the total average, or total averages, okay? So I'm going to be communicating the total averages. But if you want to look at your individual performance, the folders are also available. Certainly, like we've said, everyone really scored well, but there's always a winner and one who comes after the winner. So, the appellants, your total average is 80. Yes, clap if you want to clap. Great. The respondents, I can see Echo is, relax. There is life after this. Your total average is 85. So both of you did well, but we agreed as a team that there was one person that was really very outstanding, and that is Miriam. And personally, because Miriam, not that the other people are not good, because Miriam seems to be a very good researcher, I will take her on as my research assistant. To get some pocket money, there is no salary. But to get some pocket money, because I can see she's very passionate about access to justice for women and children. And when Justice Joel was speaking, he said, when you are addressing, you speak to the mind. I remember in my law school when they were telling us how if you're a prosecutor and you're leading evidence and the offense was committed at night, the way you speak should be different from the way if the offense was committed during the day. In the wee, then you stop, then you fix the statement so that you can get the mind of the judge to put him at the scene of the crime. It was at night, you know? If you're talking about, you pause. If you're talking about a dangerous weapon, the way you bring it, the judge should be able to see that indeed the instrument that was used to commit this offense was a dangerous weapon. And that's what you're doing. You're improving on your art of advocacy. Congratulations, guys, and the rest of you, I wish you good luck. In your career, we meet in court, the real court now.
Hello? Hello? Team CLME, what is that? Not Juju. But congratulations to you, and congratulations to the runners-up in the semi-finals. Please clap for the winners. A big round of applause for the runners-up. A big round of applause to Miriam. Where is she? Why is only one team clapping? Guys. Congratulations to you all. Yeah, so thank you so much for the participation in day one. Next up, we're going to have an award ceremony. We are going to award the team that prepared according to their lordships. We are going to award the team that prepared the best pleadings. We are going to award the team that prepared the best submissions, the best treated submissions. And then we are going to award their lordships. We are going to appreciate their lordships. I think another round of applause for their lordships. So thank you so much. At this moment, I'm going to call upon the people that are going to prevail over the next session, and that is Noor Nachibuka Musisi. She's the Deputy Executive Director in charge of programs at the Center for Health, Human Rights and Development. A round of applause for Noor. She is going to be supported by Dorothy Amron. I already introduced Dorothy. Dorothy is the Manager, Strategic Litigation at the Center for Health, Human Rights and Development. Let's clap for them as they make their way. Okay, thank you so much. As this session goes on, remember you know the winner from teams that appeared before this panel of justices because you are in this courtroom, but they are not yet officially announced by our statistician. Do you predict that anything can change at this moment? What if it changes? I want to know what you want to do. What if it changes? You do what? You detest. Okay, so we have our statisticians. He's ensuring that everything is right in order. He's very meticulous. He's doing the right job because we had another two teams which were appearing before panel 2 in the other hall. So we are going to also hear from him about who has won from the other side. And then but that is that's after the award ceremony. So we shall give him some time as he does his job. So after the award ceremony, we shall have Frank announcing to us the teams that are eligible for the final round, which is going to be tomorrow. Then after Frank, we are going to have our closing remarks from the Deputy Executive Director for SEHAD, that is Madame Noor. Thank you so much. Okay, a slight change from what I announced is that as we give our statistician to some time to compute the marks and give us the final mark, I'm going to give on to our Deputy Executive Director in charge of programs at SEHAD to give her remarks, and then we shall go into the award ceremony. So thank you so much. A round of applause for... And
all right, thank you so much. I am really humbled to stand before you this evening. Good evening, all of you. I really want to appreciate you all for being here and appreciate the Center for Health, Human Rights and Development for organizing the 9th MOOT. I have just done some quick math and I realized that we actually started the MOOTs way back in 2013. So this year marks the 9th MOOT court competitions. Just to give a brief background as to why we actually opted to take on the MOOTs as annual events, the intention was to let you know, understand the Constitution. Yeah? And I was really thrilled to look at the various students present with copies of the constitutions there, while some had the provisions of the Constitution offhead. So the intention was to kind of provide knowledge to the students to understand our mother law, but also try to see that what we have in the Constitution can be brought back into practice in various angles. And the MOOTs that you hold do not come from Mars. We sit down as a team and think through what the competition will look like. So this particular one started way back in March this year to start thinking about what the students will be asked to present before the various courts. And it's exciting that what we thought would come out has come out in all angles. So I want to appreciate you for that. Second, I want to be grateful to God that we are alive. Just this afternoon, one of the clerkship students from ALDC has passed on. Some of us, she's a relative, others she's a friend, others she's a student. And this is Nachiboneka Jalia. I think she was at Lira campus ALDC and has been in internship, but she has been crushed dead. So we should be grateful to God that we are alive. I want to appreciate the justices of the court. We are really humbled, your worships. We are extremely excited because I feel like you have given us a lot of time here. It's rare that we'll have this team in a room away from court to be in such a room the whole day. They were here before many of us. And the first conversation I had with them, they told me, should have told us 8:30, not 10, as the time for the first round. And I told them I'm taking back this feedback. For me, that shows commitment to even speak to you before. Unfortunately, in the morning when they were here, we all sat on our desks and did not utilize that time. And I loved the last panel that I was seated, that I saw here, when one of the judges said, when I meet young people, I want to leave a word or two. And the recommendation of network. It's quite important that when you get into a room, you network. The world is so small. It's really small. And if you're seated on a desk with the university students that you came with, then you have not picked the value of networking. So I really want to appreciate you. I also want to appreciate you. Sometimes the students don't get the MOOT process really happens. SEHAD does not engage in the MOOT process. SEHAD's role is to organize such a room and sit here. Sometimes even the MOOT problem is given out for somebody to review and make sure that we have what we want to take forward. So the pleadings that you drafted, our role was to hand over to this team. They took that time to review, they took that time to analyze, they took that time to even provide feedback, and we really want to appreciate you for that. And they also go ahead to look at the submissions that you actually sit down and research. So we really want to appreciate you so much, dear justices of the court today, for that guidance that you have provided. And I love the fact, I think this is my first MOOT to attend full time, the whole day. I looked at the students and the guidance that was being provided on court decorum, and I thought that perhaps we should do more of this. I feel like the students are receiving that first-hand information from the people themselves that you're going to face tomorrow. So I hope you've taken on that guidance that you've been provided. The presentations, you've received a lot of guidance on presentations, on court demeanor, and please don't take this for granted, because that's what you're going to actually see in practice. So we really appreciate you so much for the guidance provided to the students. And allow me then appreciate the various universities and the students that are in here. I have been duly informed that we have 12 universities in the room, and that the invite was extended to 14. So the 12 that are here are really special. You're really special, universities. First, for even accepting to be part of this 9th MOOT. When we released the MOOT problem, we received several emails. I don't remember which universities, but the emails came onto the institutional email to say, we want to be a part, how does this happen? And I kept saying, please go on the website and read, because I didn't want to feel like I'm biased to any student, but I really needed the students to get onto the website and pick the MOOT problem and pick the instructions and be able to respond. Sometimes you get out of it not to be biased, but also because we have gone through the same universities that you're coming from. So we really want to be independent away from that conversation. So we really want to appreciate you for choosing to read, because that university that did not read, I think all read. How many universities do you have in Uganda that teach law? Do you have only 14? Because at least 14 expressed interest. But we really appreciate the fact that you chose to be part of this MOOT. And I really want to appreciate you for organizing. I am very certain you spent sleepless nights. I'm sure you read the problem and you are not sure what you should present. It had several things. It had COVID, it had pregnancy, it had abortion, it had, forgotten the other. But it had several things. So you would really be swayed away from his need. At one moment I thought, understand the problem. What really do we want to tell students? Until I sat and read and read and read and said, okay, this is good. I want to appreciate you so much for organizing. I have seen a lot of teamwork. A lot of teamwork. During lunchtime I said, I hope I'm not on a desk where students are, but you would see that they don't even want to eat. They want to go and it's about confidence. And indeed it's about confidence, because you have read, you will read and have everything in the head, but are you able to confidently stand and speak about what you read? And I kept telling them, go for tea, please take tea, eat. So sometimes we need to relax, otherwise we'll break. So thank you so much for spending those sleepless nights. I am very certain that the research that you took time to do has come out here. You have presented very comprehensively. All of us, we have really done well. And what you presented really showed that you have put in a lot of time and that you had a team that was supporting you. I'm not sure if our lecturers are here, but if they're not, please appreciate them, because they have prepared you well. I also want to appreciate you for the time that you've spent to attend here. You have been smart, not just on the dress code, but also the brain. We have seen smart brains in this room, and you knew what you really wanted to do. So thank you so much, dear students and universities. Appreciate the universities for accepting you to move from wherever you've come from to get here. We intentionally did not make mention of the names of the universities because we didn't want to bias anyone, and we'll make mention of the names of the universities participating here tomorrow at the end. So let's know that we have 12 universities in the room. I want to thank the clerks to the court. You really did well. I think we had about 6 clerks. Thank you so much for managing us and clerking us. you really showed us what the court process looks like. I'm very certain that the guidance, again, that we received from the judges was really important, but also for us as students to know that we don't sit until when the judges have really taken their seats. So that was really important. It was not for because it's this, but it's the actual practice. So I want to appreciate you so much. We have media in the house, and when I speak about media, I speak about the influencers, the ones that are doing live streaming and all others. Some are on Facebook. You have made us proud because you have allowed our fellow students that are not in this room to actually be part of this particular session. Thank you so much for taking on those cameras since morning and for updating the teams that are not in this room. We really can't thank you enough. Allow me to appreciate the SEHAD staff. The SEHAD staff should stand up for recognition. I think we have than 10. Hey guys, where are you? We need to clap for this team. When I say SEHAD staff, I also include the clerkship students. Please, your staff. Our dear clerkship students, can we see you attached to SEHAD? And they our dear clerks, yes. Because part of what they're doing at LD to see what actually happened. It's quite important. It was important for us to have them here. I have now said that we have clerkship placements upon application and allowing us to come in. So I want to appreciate the staff for, first of all, conceptualizing the problem that you have been discussing here. I earlier indicated that what we present to you actually comes out of the things that we have seen that actually happen to people in the communities that we stay. It's not a one-man's engagement. The team sits and says, when I was in Buyukwe, this thing happened. When I was in Gomba, this happened. When I was in Bara, this happened. When I was in Koboko, this that move around the country, coming together and conceptualizing what we have looked at today as our problem. So I want to appreciate you so much, dear team, for conceptualizing, and I want to appreciate you for engaging the universities. When Esther was speaking here, she said, I have been bugging you with emails and calls, and this morning she told me I am not well, and I told her I can totally understand. It's an exhausting process. It's very exhausting. So I want to thank you so much for the time you took with the universities for developing the tools that have been used by the judges, by yourselves, by the study team, the team at the center, have been tools that have been developed by this particular team at SEHAD. So we want to appreciate you so much, but also identifying the ideas. What ideas are we thinking about? This time, I think around lunchtime, we asked a question, but did we think about culture and the Constitution and health? And I said, maybe next time, we think about a MOOT in that area, because there are things that we see every day. So please, we have ideas perhaps for the 10th or 13th MOOT on that area, but also ensuring that the pleadings come in on time. So when they came in, I know the team sat down to even tally. Compare, tally, now send to the judge, now do this. It took time for this team to put these things together, and I want to thank you so much for taking forward this. But also identifying which hotel. They'll come and tell you, want to go to a hotel, and you're like, okay, which hotel will give us 4 rooms? 4, 6. We are using 6 rooms of the hotel, tentatively. So thinking through a hotel that will bring all of you together. It's not easy. I think we always have our MOOTs here because it's very easy. First of all, it's disability friendly. Yeah? Apart from today that we're disorganized by the rain and had to slope down. But we usually think about that bit of, because we're a human rights organization, we really think about that. But it's not to say that others are not, but also where people will comfortably access the fact that we're dealing with students, and therefore we must be sure that they're near town. So thank you for identifying that. And also for being available. This team has been available here since morning, wholeheartedly, body, mind, and soul, here. At any one moment, I would ask a question and the person would tell me, here. At any one moment, you say, where's the microphone? Somebody would run to the hotel to see that the microphone is available. So while I sat down, I was really observant. I want to appreciate the SEHA team for that. I want to, in a special way, and this is not to discriminate you, to recognize Seth. Seth, where are you? Please come. Come for a photo. Recognize Seth, recognize Esther, recognize Ruth, and Dorothy. In a special way. Esther, where are you? She's sick. We are sorry, Esther. We'll take you back home, we'll take you to hospital, and we'll make sure that you're well. So, Ruth, you have refused to come, but this team, Esther is sick because the MOOT has overwhelmed her. I'm telling you, she's in that state because of the MOOT. Towards the end, towards the actual day, you feel like, will this activity really end? So this team should be recognized in a special way. They have been behind the MOOT. Every year, there's a team that works on the MOOT. Esther is joining the team because she has the background to the previous MOOTs. So she has to support the new team that is organizing. But also because Dorothy is the manager of our strategic litigation program, she has to give the oversight. So I really want to appreciate you so much for taking on the mantle. But this team has not worked alone. You see those things are saying, you have branded. We only missed the word MOOT somewhere. Please, you can take your seats. We had a team behind the branding. And the team is very silent, but Jackie and hey, people have not even seen you. Please come over. These ones opted to, you would just check in and say, but who knows about the MOOT? Who knows about it? And in a minute, you see a flyer out. And you're like, how did they think about a flyer in 2 minutes? You see, being that it's live, it would be very unfair for you to present and your parents are not watching. These ones opted to say for us, we shall sit back and communicate about the MOOT. We appreciate you so much. One of them is not here, but working in the background. He's in Namutumba. Fatah is in Namutumba, but I asked the team, where is Fatah in the room? I don't see him. He's been communicating as if he's here. So we really an event that everybody has seen, and you can take your seats. And I really want to appreciate Frank. I know he's doing the math and calculations, and I'm going to give him 1 minute to come and present the results, perhaps. Frank is our M&E person, but I'm sure how he calculates is the only person that I'm sure the lawyers may not know how the math is done, but he will tell us, when I calculate here and I put this in Excel, I'll get these results. That's why he's seated and separate and alone. The role of the team members that have really worked so hard is to come and say from the clerk, from the room, this courtroom, these are the results, and to make sure that we don't influence anything. So Frank, I'm sure you're busy, but if you could just stand up for recognition, that would be excellent. Thank you so much. And allow me to lastly appreciate the hotel. When the security person came in and said, don't move, we are digitally monitoring, I was like, what is this? I have been here severally, I hadn't thought about that. Then I realized that sometimes we leave our property and we end up saying our property is not here. So I want to appreciate the hotel for giving us such a secure environment. I'm very certain no one has lost their property. And we commit that even tomorrow we'll not lose our property. And I want to appreciate us all. So thank you so much for taking on the mantle to have this MOOT. We commit to have it annually, and other commitments that come with the MOOT, they'll come tomorrow. So I will take a step to recognize our dear judges for the day, for really accepting to be part of this particular engagement. I'm very certain we're with you here and today, and perhaps not tomorrow. The results that you had one. You started with the pleadings, you moved into the submissions, you moved into the hearing. It's granted. So, Kambeda Lydia. for, pardon? For your outstanding contribution as a judge for the round of the National Inter-University Constitutional Law Moot Court Competition. We don't take your time for granted. Thank you so much. Allow me also appreciate His Worship Lumunye. We appreciate you, Your Worship, for the time you've spent with us. Thank you so much. Then, Her Worship Nangobi Miria Jackie, for your contribution as a judge during this moot. We really appreciate you so much. Thank you so much. Her Worship, Eriot Esther Joyce. Ario Court, sorry, I didn't mention the name well. We appreciate you so much. His Worship Joel Wegoe. Hey, but the hand claps real. We appreciate you, Your Worship, for your time. Thank you so much. And His Worship Opit Christopher. We appreciate you so much, Your Worship, for your time. So can we really clap our judges for that day? Yeah. So I'm going to ask him to put a little behind some bit of time, and I will request that when I read out the next two, we come him, but I'm going to humbly request our judges for that day to come and support me award the universities. Will this space be enough, or do you want to also hold it behind? So if you could join me. Yes, please. Thank you. So as universities presented as universities, I need to be in the middle now, right? So we kept looking onto various things, and this is not to say that we'll not award others. The session still goes on up to tomorrow, but allow me to take special recognition of the following universities. And I'll request that when we read out the name, you're going to ask. So we'll request that when we read out the name of the university, you kindly come and take a photo with the judges, yeah? So allow me to recognize the university that presented to us the best pleadings. Shall we guess what that university is? Pardon? We don't know. So allow me present to you the university that presented the best pleadings, and this is none other than Gulu University. Please come as a team, yeah? Because you work together as a team. Wow. Or shall we clap for them? enjoy the photo moment. Please give us the best smile. And hold your certificate. Let's give them a round of applause. Please feel free to give your photo together because I'm sure you would want to pin it somewhere. Feel free after this to take a photo together with the certificate, yeah? He will give you that. So also, when we get pleadings, the next thing would be that we really want to see how the submissions look like, yeah? So the skill of writing submissions has come out with that university. Shall we? Which university has given us the best written submissions? We have all done well, but the procedures within the law that you have to follow as you write specific things, and this is one of the reasons why these are being rewarded. So Kampala International University, best written submissions. Please come with the third chair. The three. So we can clap for their seats. Congratulations to the universities and congratulations to all of us. Allow me to request the judges to take their seats now. So then as Frank prepares himself, I have been notified by the Silent Comms team that they actually would love to have a group picture with all of us. Frank, we're waiting for you as we take a group picture with all of us. Shall we fit here though? So we're going to request that the judges take the seats up. Oh, there are three. But others will sit and others will stand, then most of us will come here. Okay, just I think we need bits of changes. I've been guided that Frank is ready. But when Frank finalizes, please don't get pissed and move out. You really need the picture as a team. So I will hand over to Seth to call upon our, is this now Electoral Commission? We even fear what the results will be, but we have a hint of what they look like. So allow me stop here and call upon Seth to invite Frank. Thank you so much.
Thank you so much, our Deputy Executive Director. A round of applause for our Deputy Executive Director. Yes, at this moment, without wasting time, I welcome the manager of the Tally Center to confirm what has been read to you already. So there will be no surprises, I guarantee. Over to you, Frank.
Thank you. Thank you so much, Seth, and the team. First of all, I want to acknowledge the team that has really been supporting me behind there, the clerks that did a tremendous job in as far as gathering the marks or the results from each of the courtrooms. I also want to acknowledge the judges that wrote the marks on those sheets of paper. I want to commend the team. The judges didn't make any mistake in as far as calculating the averages is concerned. So these are mathematicians in the other way, or in one way or the other. Then I also want to thank the participants. It's not an easy thing to really start the journey and then you push it on up to the semifinals. For those of you who are fans of soccer, you know what it means when you go for the knockout stages and so on. So these are we've already got results for each of the teams. So I'll just mainly go to the averages in terms of the universities. Now, at the semifinals, we had 4 teams. We had Team K, Team F, Team L, and Team E. And the scores were as follows. we had team K scoring 74.8%. I will say it again, team K, 74.8. And then we have team F scoring 85.7%. And then we also got team L scoring 80%. This is 80.0 to be exact. And then lastly, we have team E that scored 85.2%. So I didn't read these in order, but if you want them in order, team F came first with 85.7. Team E came in second with 85.2, so it was just a narrow margin. That's why when we are calculating these things, we put the point, because 80.0 is different from 80.1. Just like the high school, is it the GPA when you are going to university, the way they calculate those things. So someone with a CGPA of 4.32 is not the same as someone who scored 3.21. They're quite different. And then team L, 80.0, and lastly, K, 74.8. And I take the opportunity to thank the participants for coming all this far. I really feel sometimes a bit hard, but not everyone can go to the finals, that's exact. And not everyone can be a president of a nation. So tomorrow we shall be deciding who is the president of the nation between team E and team F. I wish you good luck. Thank you.
Thank you so much, Frank. Another round of applause for Frank, please.
And then if you want to see all your marks from the starting point up to this point, please, I'm behind there. Thank you.
Thank you so much, Frank. So briefly, our last session is going to be the group picture with the judges, as our comms team has requested. But before that, I am going to request the coordinators of the finalists to step in front and participate in this draw. By this, you're going to tell who is the applicant tomorrow and who is the respondent. So then you can prepare accordingly tomorrow. But after this, we're going to have scheduling, but that's after the session has closed. I'm going to reach out to you, the teams, and we schedule so we know that the issues we are arguing before the Supreme Court. So coordinators, kindly step in front. Coordinators, Team E and Team F. So you're going to pick one paper each, and then you read to us loud. You read out your name and your side.
Godfrey, and we shall be respondents. E.
Team F, and we shall be the appellants.
Thank you so much for that, and we wish you the very best. I hand over to the comms team to organize us for the group picture. After that, you can depart at leisure, but for those who are invited and to whom logistical notes were sent, please feel free to check in. Your rooms are ready, and do whatever you want after here, please. Make yourselves comfortable. Yeah, and please cheer up. Congratulations, of course, to the winners, but please stay around and cheer them on like they've told you. We are They are just winners here, but they are colleagues outside there. So interact with other teams. Don't cocoon. Interact. Tomorrow we are going to ensure that everyone sits with at least someone from a different team, so that you can, yeah? You never know who you sit with. You could also get some pocket money like Miriam. So thank you so much. Over to the comms team.
So there's been a question of what are these teams that have made it to the Supreme Court, and I think it's just fair that we communicate since we don't have the judges here. I think it's Team F is which team? Makerere? Pardon? Makerere University and Cavendish. So they're the ones that have made it for purposes of breaking the rules and knowing which team has made it, but also because you're not going to be with us here. But please, the other members, you had better joined these teams and divided yourselves and know that we are going for appellants and respondents. You pick a thing or two. Let's support each other and support the team that will win. Thank you so much. Hey, we didn't even clap for the universities.